reliance on money or bail bonds, money bonds, that effectively, as we all know, become a form of pretrial detention for poor and minority felony arrestees. And this is a very exciting part of our reform that we're implementing. We are going to do considerable training of judges and probation officers on pretrial release decision-making, implicit bias, which was so well done this morning for us, and the proper use of a risk assessment tool by the probation office so that it is not biased in any way. And that's exciting. I say it's exciting because we have an upcoming training coming in Duluth. Cynthia's been so tremendous in leading us in this. And our Associate Director, Solomon, too, and the people from Pre-Trial Justice Institute. We're putting on a training for judges and probation officers on Friday, July 27th in Duluth. We're going to bring nationally recognized experts in this area to train us judges and probation officers. And so with that, that's really how we're implementing the reform. I want to end with just one reform that has created in me personally, in being part of this project, this Racial Justice Improvement Project. As I said, I was a prosecutor for 35 years. Being a prosecutor and an advocate, of course, I never charged anyone unless they were guilty, right? Because I made that decision, not on a probable cause basis, but that I could prove the case beyond a reasonable doubt when I made the decision to charge. And so, as a prosecutor advocate, of course, I thought that every person charged with a felony should be in jail to protect the public safety and to prevent further occurrences of criminal conduct and to make sure that that person came to court at future appearances, that made future court appearances, and that there was no public safety risk. So my bail recommendations were typically very high, as they still are from the prosecutor's office, which is an advocate on one side of the equation. So I came to the bench, and I still had a lot of prosecutor in me. Yes, I believe that I was trying, and I tried right from the get-go, to be the fair-minded, open-minded, no longer advocate judge. And yet there was still a lot of that, as I say, prosecutor in me. And so about a year, within the last year, since my involvement in the Racial Justice Improvement Project, where I heard a wonderful talk by Judge Morrison in Kentucky. Those of you who didn't even go to the Kentucky Pretrial Justice Seminar last September, he spoke and he reminded me so eloquently that the only purpose, the constitutionally correct purpose for pretrial detention, or the decision-making for pretrial detention has to be based on, number one, the presumption of innocence and public safety concerns. And the other things may become even irrelevant. They weren't irrelevant to me as an advocate. And so, since my involvement with the Racial Justice Improvement Project, I had a Native American woman come before me on a bail reduction motion. And it was what I call an aha moment for this judge, 35-year prosecutor, a former prosecutor. I had a Native American woman who was in jail pre-trial on a felony charge of terroristic threats, involving a wielding of a knife and threats to a woman another woman she did not have a relationship with. It was what we'll call a random victim. So there was not a likelihood, certainly, of being with or in that person's home again. And the motion came before me to reduce her previously set $10,000 bail. And in support of that bail reduction motion, the defense, the public defender asked if her father could speak. And he came before the court, had a microphone much like this on the podium in the Raymond courtroom, and he said, "Judge, I can assure you, number one, that public safety will not be a problem here. I live in Cook. Now, again, for those of you that don't know St. Louis County, I just mentioned how long it is. Cook is about 160 miles north of Duluth, where the St. Louis County Jail is, and where she was charged in the Duluth area of the county where it happened. And she will be at my home, and I will watch her, and so you don't have to worry about public safety in this community or the victim's safety, because she won't be anywhere near it. And if you're worried about, Judge, and he said this with a straight face, it took me aback. He said, if you're worried about her getting away, in Cook we are very rural, and I'll chain her to a tree. Now, it did take me back, but the purpose of my aha moment story to you is this. In the analysis that I have in front of me, which would not have come about but for this racial justice improvement project, reform and education, for me personally, I said, what is the likelihood she will make her next court appearances? Oh, and he said, I will drive her to every court appearance. I have a driver's license. She does not. She will make them. I had that assurance from a father. What is the public safety concern here? She's going to be rural. I think she'll be chained to a tree by her father, but he's going to watch over her. There was none.